Hello and welcome back to Newsroom Nigeria. This is where we give you hot, fresh and sizzling news all day long. If this is your first time here, you have not subscribed to this channel, what are you doing? Please go ahead and subscribe. Also click on the like button that we were encouraged to keep giving you more reliable and authentic news. And also YouTube is able to keep recommending this video to other YouTube viewers all around the world. Lastly, please leave your opinions in the comments section below. And without further ado, let's delve right into the details of today's news. The Federal High Court in Abuja on Friday adjourned the hearing of the alleged money laundering case instituted against the immediate past governor of Kogi State, Yahaya Bello, by the Economic and Financial Crimes Commission, EFCC, to June 26, 27, and July 4 and 5, for ruling on the request by the prosecution to cross-examine the third witness and for continuation of trial. Justice Emeka Nwete adjourned the hearing after listening to addresses by the prosecution and defense counsels on the prosecution's move to initially cross-examine the witness, a position that was rejected by the defendant's counsel, Joseph Daudu San. When the matter was called for continuation of cross-examination, the defendant's counsel asked the witness, Nicholas Ojeomon, whether he had testified in other courts with respect to the issue of school fees paid by Bello family to the American International School, Abuja. He said yes, but the witness, an internal auditor at AISA, said he could not mention the exact courts. He admitted testifying in a similar charge involving Ali Bello, but added that he never said anything adversely against former Governor Yahaya Bello, just as he had not said anything negative or adversely against him in the instant charge. After Daudu San concluded the cross-examination of a witness, Nicholas Ojeomon, the EFCC's lawyer, Olukayode San, moved to also cross-examine the commission's witness on Exhibit 19. He told the court that he was not re-examining the EFCC's witness, but cross-examining him because the document was admitted in evidence. I am not re-examining him. I am cross-examining him because they brought this document, he said. The defendant's lawyer, however, drew the court's attention to the fact that the prosecution counsel's position was unknown to law in line with the Evidence Act. If you want to cross-examine your own witness, you have to first declare him a hostile witness. You cannot cross-examine him based on the document, Daudu San argued. Eniton San added that he had the right to draw the attention of a court to some specific paragraphs in the document. At this point, the judge asked, "Do you have any provision of the law to support this? I would draw your lordship's attention to Section 36 of the Constitution. They sought to tender these documents. We objected and the court granted their prayer. Fair hearing demands that the complainant, too, has the right to examine this because Section 36 of the Constitution talks of fair hearing," and it responded. "We are not saying that they cannot re-examine the witness. That is what Section 36 under the law says about fair hearing. But if it is to cross-examine him, he will have to show us the law that backs that. It cannot come under the guise of fair hearing to want to cross-examine the witness," the defendant's lawyer maintained. The judge, at the end of the argument, refused to allow cross-examination of a witness by the EFCC lawyer. Under the procedure, the witness gives evidence in chief, and the defendant cross-examines, then the prosecution re-examines. With due respect, what I would do is, if you people are so scared to continue with this, it is better to address me on this, and I would take a position, he stated. At this point, the prosecution counsel agreed to re-examine the EFCC witness, and the judge gave him the go-ahead. "You can re-examine him on that, but not to ask questions that would show cross-examination," Justice Nwete said. However, when the prosecution lawyer proceeded to re-examine the witness, and his questions pointed at cross-examination, as observed by Daudu San, the judge insisted that the parties had to address him on a specific issue. The defendant's counsel, in his address, maintained that the position was unknown to law. He said, and I quote, "My lord, the procedure that is being sought by the prosecution by referring the witness to the document tender in Exhibit 19, and by asking him to read paragraph 1 without drawing his attention to the issue on how the document affected his evidence in chief, the question asked in cross-examination, and the ambiguity, which needs clarification, amounts to a strange and unknown procedure not covered by the Evidence Act, it stated. Any concern disagreed, saying that in the case of Amobi referred to by the Defendant'S Counsel, the Supreme Court held that the learned trial judge ought to have allowed a re-examination of Exhibit E. He said when the defendant sought to introduce the document, the prosecution team submitted that this document was not made by the witness, and as such, he should not be allowed to speak to it under cross-examination or allowed to be confronted with it. Having brought it in now, during the case of a prosecution, particularly during the cross-examination of PW3, your lordship should not allow them to shut us out, as that would amount to the court allowing them to blow hot and cold, Penrose San said. Justice Nwete thereafter adjourned to June 26, 27, and July 4 and 5 for ruling and continuation of trial. The third prosecution witness had, at the last hearing on Thursday, said there was no wire transfer of fees from the Kogi state government or any of the local governments in the states to the account of the American International School, Abuja. He also read out a part of a previous Federal Capital Territory High Court judgment that said there was no court order for AISA to return fees to EFCC or any judgment declaring the money as proceeds of money laundering. What are your thoughts? Let's have them in the comment section below. Thank you very much for always listening and watching. Before we go, guys, let's take a look at some of the reactions we got online. Elisha Oluwole says, if Yahaya Bello escaped judgment, it means judiciary is the problem of this country 100 times. SN says, Wahala. When it is Emelo Cotton, they hide here and there. When it is Igbo, we hear ho. Ademolaadeleke says, delay tactics, waiting to the remaining months of May to listen to waiting happen. Ernesto Yebuchi says, at the end of the day, the lawyers will turn the whole thing in favor of Yahaya. Cost may even be awarded in his favor. That's the tragedy of Nigerian legal system. Investigation will show that this is part of the reason behind jungle justice. Police and judiciary justice are fake. Samuel says, every Tom and Harry knew Abinitio that Yahaya Bello stole government money, but at the end, the so-called learned people will say because of technicalities, the case will be struck off. Only God will help Nigeria. Benedict Stanley says, billionaire defendants, you'll see how they will keep tampering this case till 2027. That is if it does not even extend beyond 2027. Samson says, it is only in Nigeria that people will steal all the money while in office, then go to court and do plea bargain, take 50% of the loot. Most of the members of the NAS are like that, thieves. Lastly, a comment from Johnny says, funny thing is that the useless Nigerian judges we have, we like EFCC to undo VDM matter well, but they are blind to this one. They term it normal, yet they want change in the system. Thank you very much for always listening and watching, guys. I'll see you in my next video. Bye for